Judgment in the matter of the Queen on the application of AR versus the Chief Constable of Greater Manchester Police and another.
Lord Carnwath will explain the decision of the court.
There are reporting restrictions on this case. The court has ordered that no one shall publish or reveal the name or address of the appellant or details of his family. The case concerns what are called Enhanced Criminal Record Certificates, or ECRCs. Applicants for certain sensitive forms of employment, such as teaching, may be required to obtain an ECRC from the relevant central authority. Unlike an ordinary criminal record certificate, which is limited to the facts of any convictions or cautions, an ECRC may include information on the basis simply of the chief officer's opinion as to its relevance and whether, quotes, it ought to be included in the certificate. In this case, in January 2011, the appellant, AR, was acquitted of rape by the Crown Court. He was a married man of previous good character and a qualified teacher, was working at the time as a taxi driver. It was alleged that he had raped a woman who was a passenger in a taxi driven by him. Following his acquittal, he applied for an ECRC in the course of an application for a job as a lecturer. It gave details of the rape charge and his acquittal. He didn't get the job. He applied for judicial review on the grounds that the inclusion of this information in the certificate was a breach of the presumption of innocence under Article 6 of the European Convention and of his right to privacy under Article 8. His claim failed before the judge and in the Court of Appeal. Permission to appeal to this court was limited to Article 8. The Supreme Court unanimously dismisses the appeal in a judgment given by myself. The judgment considers the approach of an appellate court in such cases and holds that the issues of justification and the proportionality of any interference with his rights were matters for the evaluation of the trial judge. The purpose of an appeal is to enable the reasoning of the lower court to be reviewed and errors corrected, not to provide an opportunity for parties to re-argue the same case or for the appellate court to make its own evaluation. There was a complaint of lack of consultation of AR, but the judge was entitled to reject that complaint because the officers were fully aware of the nature of his defence and his personal circumstances, and there was no indication of any further information he would have wished to advance. The court also rejects the submission that the interference involved in the disclosure could not be justified unless the officers were in a position to form a positive view of likely guilt, or that it was necessary or appropriate for those responsible for an ECRC to conduct a detailed analysis of the evidence at trial. The judge was entitled to accept the chief officer's view of the potential relevance of the information and that it was not lacking in substance and the allegation might be true, notwithstanding the failure of the prosecution to prove their case beyond reasonable doubt. It was a matter for him to assess whether the information was of a sufficient weight in the Article 8 balance. He took full account of the possible employment difficulties for AR, but regarded them as no more than necessary to meet the pressing social need for which the ECRC process was enacted. So the appeal is dismissed. However, in a postscript, the court expresses some concern about the lack of information as to how the ECRC scheme works in practice in cases of this kind, and of the use made of such information by potential employers. It calls for further study outside the context of this appeal.
The court will now adjourn.